Today I'm going live. I'm going to have a quick chat about prenups or I suppose prenuptial agreements, which means premarital agreements. So I was reading in the papers that sadly the marriage of Jerry Hall and Rupert Murdoch seems to be in difficulties, or that's what the papers are saying. And I guess if it's in the papers, given he controls a few, then I don't think they'd be printing it if that wasn't the case. It just put me in mind of talking about prenuptial agreements, because it's possible that there's one there, given that these are parties who had assets before a marriage. We had an inquiry that came in about a prenuptial agreement, so just was thinking I'll have a look at that and see what the lawyers might be saying about this. So the position in English law is that parties can enter into an agreement before a marriage, which if they do separate and there is a divorce and there are financial remedy proceedings, the court can and will take that into account. It's not necessarily binding, and it would depend on the circumstances, and that's what I'm going to be talking about to you today. If you've got any questions, put them in the comments down below. Obviously, give me a wave if you can. If you can have a bit of love given, always helps the metrics, so please do so. So prenuptial agreements, so what are they? Prenuptial means before the nuptials, before the marriage, and you can also have a postnuptial after the marriage, after the separation. Another thing, slightly different considerations, not going to talk about that today. And you can have agreements within the marriage. So an agreement that's made prior to a marriage would normally be considered when one or other of the parties has substantial premarital assets that don't derive from anything that the person they're marrying has brought into the marriage or has done. And it can, in fact, a lot of the cases seem to be where it just happens that they're women who have very substantial monies from inheritances, running into the tens or hundreds of millions, extremely wealthy, and are marrying a partner who doesn't have those kind of assets. And so the concern clearly is that they're trying to avoid a sharing of assets on any postmarital division. And if there are no assets before the marriage, if parties, they might marry when in their mid-20s, where they haven't established any assets, that would be very different. But let's say these parties, let's say they are 65 and 85, and the 85-year-old has extremely substantial assets. It might be that there would be an agreement that those assets would be completely clear of any consideration within the marriage. And what would happen in that case is that each party would ideally have their own lawyer, because having independent legal advice would make the agreement stronger. And they would have these discussions. It might be round table meeting or discussions via their lawyers, and they would do it well in advance of the marriage, because you wouldn't want to do this firstly, it wouldn't be a very nice thing to be doing just before you were getting married. It's something to do well in advance, because obviously not the we really want to be thinking about the night before, but also because if one party were to say that there was duress involved, that they didn't enter into this agreement with their free will, that would be a reason why it wouldn't be followed. So the most important thing would be that it's done in good time, that there is, if possible, each side is independently legally advised, and that there is disclosure of assets. And it can depend, it has to be sufficient disclosure, but it may not be. It may be by list, these are the list of assets this person has, or it may be giving all of the disclosure, and it may be when that's done there's some kind of confidentiality agreement that's not just put out, and because there could be you imagine if someone has many millions, that they could have quite complex financial affairs, So there would be a disclosure, and each side would explain what they currently had in their own name. Could also be the case, what liabilities they have, what is their financial position. And in its simplest form, it might say that, let's say one party has assets of 100 million and the other party has assets of 1 million. In its simplest form, it may say that the party, that with the 1 million has no claim over those assets that are coming in. There will be no claim, and that will be in its simplest form. And these agreements can be as short or as long, or as complex, or as many clauses as their lawyers may agree, and it might take a little bit of time to get all of the information there. So that is what is called a prenuptial agreement or a premarital agreement. They use both those terms. So if there is such an agreement, parties, yes, they get married, everyone's very happy, and obviously they hope that they're never ever going to look at this agreement again. Although what could happen is those agreements could be updated. If you are, often it's money's been, let's say, the wife's father might. There's a case on this where the wife's father gave. The wife never really earned anything, but the father was extremely wealthy, and so when the parties, they lived in a number of houses, and every time they got another house, there would be another agreement that the husband had absolutely no claim to the property, and her father was paying the children's school fees, so he was financing everything, and all of these agreements were saying there is absolutely no claim the husband has, and so they were making repeated agreements through the marriage. And obviously you can see that by doing that you're keeping things up to date, because one of the arguments can be, and we'll go forward on this, that there's been a change of circumstances, therefore the agreement shouldn't be honoured. So what the parties are doing with this agreement, they're making a contract between them. It's very strong evidence of what they intended. The courts do recognise these agreements now. There was a case 12 years ago. Most lawyers will know this case. It's called Radmacher. It went to the Supreme Court, and guidance was given to say, yes, the courts are, in England and Wales, we are now going to look at these agreements, and we will follow them unless, and I'll come to the but point, the unless. So I told you what the premarital agreement is, when you might want one, how you keep it up to date. And if then the parties separate and one party is claiming against the other, then the way it will be looked at is firstly, is there any unfairness in the agreement of itself? So if the court were looking at it, it would say, well, is there something unfair about that agreement? If you just look at the actual agreement, and it might be if there's fraud or mistake or misrepresentation. Let's say there was no disclosure, or incorrect information was given, that might vitiate the agreement. And so the first thing is there anything wrong with the actual agreement of itself? And then the court's going to be looking at, okay, look at now, and the court always has a duty to decide what is a fair order. The court will say, when it's considering it, is it fair to hold the parties to this agreement? So the court doesn't just say there is this agreement. If the agreement at the time was fair, we will follow it. They will say that's very strong evidence of what the parties intended, but we are still going to look at what's called the Section 25 Matrimonial Causes Act factors, which is a list of factors the court has to look at, and the court's first consideration being the needs of the children. Then it looks at a number of other factors. So that brings me to one of the reasons that the court may not uphold the agreement, or may change the terms of it. So let's imagine that situation I've said, the wife has 100 million in assets on the marriage, the husband has 1 million, and let's say then they go forward through the marriage, then have 2 children, and let's say the argument and the husband is making, well, I actually have needs, our assets are now that they've appreciated. We now have 100 50 million, and these are great figures. You know, not all cases have as much as this, but you know, just to keep it in round figures. But let's say the husband says, okay, in my name, I only have 1.5 million. Wife's going to be living in a beautiful house. The children can continue in private education. I have now not got a job. I can't find any work. I've got some health difficulties. I'm now I'm 50 years old, and everything's very difficult. He could put up a needs argument to say, look, I need to have a decent home until the children, who are now, let's say, age 10 and 12. It can't be right that they're living with their mother in that particular way, and I just don't have enough, and I need to have a home that's quite nearby, and have a decent home that they can all live in. So that would be a needs argument, and that sort of argument has been raised in cases, and the courts have said that if there are needs which go beyond, you know, what the agreement is, and in those circumstances, the court can then say, we can give, they might say that the husband should have a housing fund of 2.5 million. And what's interesting, the courts have put it like this. They've said, because children, that they make the difference, even when that agreement was entered into, a new factor is that the children are now these ages, and you've always got to look at the needs of the children, and so it's their need that they're living in a house that's quite nearby, of some kind of comparable standard to the house they're living in with their mother. And until the children are grown up or left home, they should be living in that kind of house. And it may be then that the court said this, that stage, the husband would have to pay back, or he would have to sell the house, and let's say 50% would then go back to the wife. So it would be quite close to the agreement, but you can see that the court can change it. So the point of these agreements, the courts appreciate that people want certainty, and they appreciate that people want to enter into agreements that you know, can make all the difference, because there are situations in people say, well, I just wouldn't have got married, I wouldn't have entered into this, you know, I had all of these premarital assets, and the other person wasn't forced into it. They did make the agreement, and therefore they should be held to it. And so there's that little bit of tension there between people's autonomy in making agreements, and the court's overriding duty to ensure fairness. So that's a wrap up of, you know, what is a prenuptial agreement, when might you need it, and how do the courts consider it. I've got a comment here saying, is there a backlog delays in the family courts at the moment? There's been a backlog in delays for a long time, and the pandemic didn't help. And the cases that get priority naturally are care cases. So in terms of private law, it's taking a bit of time, but all courts are different. It really depends where your case is. But it's certainly not a speedy service, let's put it that way. And the courts are, I suppose they're catching up. That some of the, you know, during the pandemic, clearly they were closed. There was a lot of cases that went ahead by video platform, and the courts are still using that, maybe in a way to catch up, I don't know. But yeah, there are backlog and delays in the family courts, and that's been the case for actually quite a while. It's not just the pandemic, but it doesn't seem to have helped it, let's put it that way. So that's what I've got for you today. If there are any further questions, this is your chance to put them now. I hope that was helpful. It's good to see you here, and we'll leave this up here, and you can play it back at your leisure. I'll be doing another one of these on Wednesday. Thank you. Bye.